Hello, everyone. Welcome to Court with Krissy. This probably would have been a great jury trial. Too bad the victim had to go and ruin it for everyone. I'm guessing it was planned, because who could be this dumb? I hope you like it. Court with Krissy is now in session.
Please be seated. We're back on the record in the Mark Thomas case. It's 25 CRB 00287. The defendant's present in the courtroom with his counsel. Mr. Savage is here on behalf of the state of Ohio. The jury is not in the courtroom, but we are coming back from our first recess. Mr. Savage, was there anything that the state needed to address before we bring in our jury and get started?
No.
Anything on behalf of the defense?
No, we already have witnesses that are, we don't have any witnesses in here, so I would have requested a separation of witnesses.
Any objection?
No.
All right, so nobody's permitted to discuss the testimony of a witness with any potential witness who's going to be testifying later in the trial. So make sure your folks are aware of that. Anything else, Mr. Itam?
No, Your Honor, thank you.
All right, very well. Let's bring him in.
All rise for the jury.
All right, please be seated. And the record should reflect that our jury is now back in the courtroom. All 9 jurors have returned. Ladies and gentlemen, before I get started with the preliminary instructions, I just wanted to point one thing out. Whenever we recess and whenever we reconvene, we will rise. We rise to honor your very vital role in this trial. So that's to honor you, so thank you. Let me be clear that you as jurors must decide this case based solely on the evidence presented here within the confines of this courtroom. This means that during the trial you must not conduct any independent research either about the case, the issues in this case, or the individuals involved in this case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, or use any other electronic tools to obtain information about the case or to help you render your verdict. Please, do not try to find out any information from any source outside the confines of this courtroom. Until you retire to deliberate, you must not discuss the case with anyone at all, even with your fellow jurors. After you begin your deliberations, you may begin discussing the case with the other jurors, but you cannot discuss the case with anyone else until you've returned a verdict and the case is concluded. I hope that for all of you, this case is interesting and noteworthy. Now, I know that many of you use smartphones and the internet and other tools of technology, but you must not talk to anyone about this case or use these tools to communicate electronically with anyone about the case, nor are you to disseminate information about our proceedings on these devices. And this does include your family and your friends. You may not communicate with anyone about the case on your cell phone, through email, text messaging, or on Twitter, or through any blog or website, through any internet chat room, or by way of any other social networking websites, including, but certainly not limited to Facebook, Snapchat, Instagram, Pinterest, LinkedIn, YouTube, TikTok, etc., etc. After the verdict is announced in open court and you're discharged, you may speak freely about the case and your experience, but until such time, you're specifically instructed to follow the directions that I've given to you now. At this time, counsel for the parties may have an opening statement. Opening statements of counsel are concise and orderly descriptions of each side's claims and defenses, and the evidence counsel expects to produce in support of those claims and defenses. Opening statements are not evidence. Each side is going to address you once during opening statements, and the state will proceed first. Mr. Savage?
The testimony of one witness, if believed, is enough to prove any fact. And that's true regardless of the burden of proof. The defense is absolutely correct that there are, in the legal system, many burdens of proof. There's preponderance of the evidence, clear and convincing, and the highest of all, beyond a reasonable doubt. And that's the standard that you will be applying today, beyond a reasonable doubt. But for any of those, if someone up there today says something, that's enough to prove that fact. Now, that's not me telling you what to believe. As the judge said, each of those statements can and should be considered in context. A few of the things that he mentioned that are good to consider for each witness is the witness's perceived intelligence, their point of view, what could they have seen, what didn't they see, their memory. One more item I would want to add to that list is each respective witness's consistency in their story. You will hear them speak today, and you also, through video evidence, get to hear the stories of the people that were involved in this back in February of this year. So you'll get to hear what they said then, and you'll get to hear what they said now, and I would ask that you consider how well those stories line up and give each its due credibility in response. Now, to get into the specifics, the exact elements of the charge are that on February 16th of 2025, in the city of Heath, Licking County, Ohio, the defendant, Mark Thomas, did unlawfully, knowingly cause or attempt to cause physical harm to another, to wit, Thomas Harvey. That is, the defendant is Mark Thomas, and the alleged victim is Thomas Harvey. Now, one thing I want to get into briefly is there are several people involved here. Those are the two most important. I'm going to go through some of the important names real quick, just so you all can know in advance who we're dealing with. Again, defendant Mark Thomas, alleged victim Thomas Harvey. Other persons involved. The witness you will hear from, the other witness you will hear from today is Amber Jones. Amber Jones is the sister of Thomas Harvey's then and still girlfriend Madison. So Madison and Amber are sisters. Their father's name is Jamie, who also goes by JJ. Jamie, JJ, does not play a specific role in this case. However, Jamie is the connection from Amber and Madison to Mark Thomas. Mark Thomas and Jamie are friends, and that is the connection there. So, we'll go through that all with the witnesses, and of course, that is the evidence that you will consider. I'm just offering it so you can know those names in advance and know what to look for. Now, as to the events themselves, this event, I told you, it took place in the city of Heath, Licking County, Ohio. It's alleged to have occurred specifically that's the important location here. And what's alleged is that Thomas Harvey was at that apartment. Earlier that day, him and his girlfriend had an argument. And that was Madison, if you remember. And so Madison had left the apartment, and her sister Amber had gone back over to the apartment to collect some things. It's alleged that Mark Thomas went with Amber to that apartment where Thomas Harvey was also packing up his things and getting ready to leave. They got to the apartment, and Madison will tell you that she went upstairs to get some of Madison's belongings, the things she was there to collect, and Mark Thomas went to the kitchen where Thomas Harvey was at that time. And next, Amber will tell you that she heard an altercation, ruckus, fight, and went downstairs and saw the two of them in a fight. She will not tell you who started it because she didn't see who started it. When it comes to who started it, you'll get to hear the testimony of Thomas Harvey, the alleged victim, and he will tell you his story in due time. But what Thomas Harvey will allege is that Mark Thomas came up to him, and that while Thomas Harvey was in the process of leaving, Mark Thomas struck him, possibly touched him on the shoulder at first. We'll get into the details, and then eventually hit him in the back of the head, causing Thomas to fall into the screen door of the kitchen, and then hit him subsequently a couple more times, causing Thomas Harvey to fall on the ground. At which time, then Thomas Harvey got up, went out the door, ran over to a nearby fast food restaurant where he was able to get in contact with police. So, that's the general situation. Now, what's been raised in response to that is the state has charged that assault. The defense has responded arguing self-defense. So, recognizing that situation, but arguing that Mark Thomas is not the one at fault. So, the additional burden that I have to prove, again, beyond reasonable doubt, in addition to proving the elements of the assault, is that in response to self-defense notice, the state must prove beyond a reasonable doubt at least one of the following. There are 4 different elements, and those are as follows. First, I can prove either that the defendant was at fault in creating the situation, giving rise to that fight in the kitchen as I described. Second, that the defendant did not have reasonable grounds that he was in imminent, immediate danger of bodily harm. Third, that the defendant did not have an honest belief, even if mistaken, that he was in imminent or immediate danger of bodily harm. Or fourth, that the defendant used unreasonable force. So, there's those 4 elements. I have to prove at least one of them, but only at least one of them. And furthermore, in deciding whether I have met that burden of proving one of those beyond a reasonable doubt, that the defendant did not act in self-defense, each of you do not necessarily need to agree as to which of those 4 were proven. Obviously, when it comes to the assault charge, you all have to be in agreement on that. That's only one charge, and you have to agree that that was proven beyond a reasonable doubt. But as far as the self-defense, those 4 options, as I read them off there, you'll hear them again later on. But each of you just need to find that one of those was proven. So, but once more, I'll revisit the question of credibility. As you're listening to the witnesses sitting there today, just apply your best judgment. That's why we chose each one of you. If I didn't say it already, thank you for being the ones that are actually serving on our jury today. And in that process, use your best judgment, listen to everyone has to say, and make the right decision. Thank you.
Thank you, Mr. Savage. Mr. Itam, your opening statement?
Thank you, Your Honor. Good morning again. This is my last chance to speak with you directly until closing arguments. So ultimately, a lot of the things that the state are saying in regards to what needs to be proven, absolutely correct. Witnesses can be enough if believed, which is the operative phrase here, if believed. Ultimately, the defense is usually in a precarious situation. We don't ultimately know exactly what's going to be presented from the state. In regards to evidence, we get discovery, but obviously once the trial starts progressing, certain things come out that maybe we didn't get, or vice versa. But ultimately, what I know is, and pretty accurate across the board, is no good deed goes unpunished. And what you did here is that Mark Thomas, my client, is friends with JJ, or Jamie, who happens to be the father of the girlfriend in this particular situation, and her sister, who my client accompanied. Well, what you'll hear is why was he with them? Well, although the state glazed over that domestic disturbance, you'll hear that there was 2 prior incidents involving this girl, that same day, involving this girl Madison and Mr. Harvey. It was Madison who left the residence for fear of this gentleman. And I think the state is definitely incorrect. I don't know if it was just mistaken or not, but Madison was never there. She was not the girl that was there. It was Amber, her sister, came back with Mr. Thomas to retrieve her belongings. Not only her belongings, her dead mother's jewelry, who she recently passed away, as well as her much-needed medication. So imagine the abruptness that she had to leave in that situation for her not to have her medication with her. And then not be the one to return to the residence, have to have her sister return to the residence. Imagine and make sense of it, of why she didn't feel the ability to be able to return. And in that, with my client's relationship with their father, an important fact that you will hear is that he is either in South Carolina or doesn't reside in Ohio, Virginia. He resides in Virginia. So he called his friend who he relied upon and said, look, please, Amber's going back to that residence. She needs to retrieve the medication. She needs to retrieve her mother's jewelry that passed away. We don't know what's going on right now. Can you please accompany her just in case there's an issue? There was no anticipation of that gentleman still being there. Amber has keys retrieved from her sister, goes back to the residence with my client to retrieve the items. Well, Thomas happened to be there, and he was not happy. My client was simply standing there while she went and retrieved the items. He, upset that he was there, started to approach my client. My client's not wanting the altercation. He's saying, we're going to retrieve the items and we're going to leave. Mr. Thomas had no beef with this gentleman. I don't even think he knew his name at the time. He simply was asked by his friend to accompany his daughter to retrieve the items and then leave. Mr. Harvey became aggressive. And what you'll hear is my client, at least from our perspective, and you will get to hear from my client today, is that my client, after he was shoved and approached, he put his hands on him, shoved him, and got him through the door. Now, Mr. Harvey, which I imagine if he's consistent with the police narrative, will say that Mr. Thomas was assaulting him, beating him up, punching him into the ground, pummeling him into the ground. But ultimately, when we're weighing credibility, is what other facts that are consistent with that type of assault? Well, we would argue, and you will hear, that there has to be some type of accompanying physical evidence for something like that. But what you will see is redness. That was it. That was the physical damage to Mr. Harvey from the altercation was redness. After 3 to 4 times being hit, being pummeled to the ground, and then being thrown through a screen door, according to what you might hear from Mr. Harvey. But is that consistent with what you see? And we don't believe that it's going to be consistent. Ultimately, this is a gentleman that had to be accompanied, that had to accompany a young lady, because this is a known, clearly at this previous incident, of someone that their own father did not feel comfortable with their daughters being around in that state, and requested a friend to accompany him. That was his real downfall here, is that he was being a good friend and accompanied his friend's daughter to the residence. And ultimately after that, this gentleman, after my client leaves and Amber leaves, he contacts the police and said, this guy basically beat me up, and please go arrest him. And they eventually locate my client, and after a brief investigation, and you will again hear from my client, he was arrested for an assault. You were charged with an assault. So, in hearing all of this, and as you start to make sense of it all, that's really, you are the fact finders here. It's what you believe and what you've seen that's important. And we believe that after you hear all the evidence, and certainly from the individuals that were there, that there's really but one verdict to get to at that point, and that's not guilty. And we hope that you find your way to that correct verdict. Thank you.
Thank you, Mr. Isam. Do counsel intend to use the lectern during the examination of witnesses, Mr. Savage?
No, Your Honor.
Mr. Isam?
No.
All right, very well. We'll go ahead and move that off to the side. And Mr. Savage, you may call your first witness.
All right. Your Honor, may we approach?
Yes, you may. I'll take care of it. Mr. Isam?
Oh,
Take yourself. All right. Well, ladies and gentlemen, something's been brought to the court's attention that we do need to address, and unfortunately, it's not something that can be taken care of in whispering at the bench, so I am going to have to excuse you into the jury room while we address this issue. I want to remind you not to discuss this case amongst yourself or with anybody else. Do not permit anyone to discuss the case in your presence. If anybody asks you about the case, you tell them that the judge said you're not allowed to tell them anything about it, including what type of a case that it is. And I remind you, it is your duty not to form any opinion on this case until it's finally been submitted to you. I anticipate this will be at most a 10-minute recess, so we're going to hopefully reconvene within that time. If you need to exit the jury room for any reason, just knock on the door. Miss Kyle will come in and she can escort you a different way so you don't have to come back through the courtroom. So with that, we'll take our recess.
All rise.
Okay, we're back on the record in the Mark Thomas case, 25 CRB 287. The defendant's here with counsel, the prosecutor's here. The court has been made aware that despite being instructed not to do so, the alleged victim was following the proceedings on our YouTube feed while in the witness room. It would be the court's intention to call him and conduct a voir dire of the witness to find out exactly what he heard, whether he discussed it with anybody else, and how that might affect how his testimony might be going forward. So if we would bring Mr. Harvey in, please. Mr. Harvey, come up here and have us stand up onto the witness platform, turn and face the bailiff.
You solemnly swear or do you affirm that the testimony about the case is the whole truth and nothing but the truth under penalty of perjury?
Yes, ma'am.
Please have a seat. For the record, you're going to give your name and spell your last name
Thomas Harvey, Harvey.
and your address.
So, Mr. Harvey, the reason you're here and the jury is not is because it's been brought to the court's attention that you disobeyed an order not to watch these proceedings on YouTube. Is that accurate?
Yes, sir.
Why did you do that?
I wasn't thinking I'd do it.
Do you realize that you've called into question possibly the integrity of this and we may have to quit today and start all over again?
Yes, sir.
Who else was in the room while you were watching that?
Amber Jones and the other officer.
Were either of them watching the proceedings with you?
I do not know. I was watching myself.
Did
on
you
my phone.
discuss what you saw or heard with either of those witnesses?
No, sir.
What did you hear?
I just heard basically him discussing that he's got to make 4 ways to figure out if the defendant's guilty or whatever.
Now, you realize that the court has ordered what's called a separation of witnesses, which means nobody's permitted to tell potential witnesses what's been going on prior to them taking the witness stand. If we're able to go forward, obviously you're not to discuss with the other witnesses what you observed or what you heard. But I don't know that there's really any additional questions that I have. Mr. Itam, since this implicates your client's rights, I'm going to allow you to examine the witness first.
Thank you. What did you hear me say?
I didn't hear nothing that you said. Just this lawyer here, sir.
So you, after he did his opening statement, you stopped listening?
Yes, sir.
You turned it off?
Yes, sir.
What made you turn it off after the prosecutor was?
She had come in. The prosecutor had come in.
I'm not a prosecutor, I'm a victim advocate.
The victim advocate. Yes, sorry.
So you were watching it all the way up to
No,
the point?
I just turned it on
Well, you heard
like 2 minutes prior to her coming in.
Okay. Did you hear all of his opening
No,
statement?
sir.
May I interject real quick, Mr.
Yes, sir.
Itam? Did you hear any portion of the prosecutor's opening statement in which he described what he believed the state would prove were the facts of things that occurred?
No, sir.
Go ahead, Mr. Itam.
Okay. Thank you. I have nothing further.
Mr. Savage, any questions?
Were you watching this on your phone?
Yes, sir.
Okay. Did you, were you playing the sound? You were playing it with sound, is that correct?
Yeah, and I had it low enough to where I just had to hold it up to my ear. That's all.
Got it, okay.
But it wasn't low or high enough to where anybody else could hear.
Okay, so you were holding it up to your phone low enough that only you could
Yes.
hear it? Okay. Nothing further.
All right. Mr. Harvey, you may go back out to the hallway. Okay, so the court's greatest concern, I suppose, as Mr. Itam brought up at the sidebar, was that if he heard Mr. Jackson or Mr. Savage's presentation of the state's version of the events, that he might tailor his testimony to conform with that description. He testified under oath just now that he did not hear that portion of the opening statement. Whether that assertion is credible or not, I suppose, is what you guys are going to tell me right now. So, Mr. Savage, what's your position well, are you making the formal motion for mistrial? Mr. Tainted?
Yeah, thank you, Your Honor. I think I do need to formally make a motion for a mistrial. Certainly not ideal, and I know my client will go back and forth on this because this has been looming over his head since February, but I do think that I need to make that formal motion. And in particular, I think he said that he listened to 2 minutes, right? I don't think Mr. Savage's opening was longer than 5, really. If he heard 2 minutes and he heard anything about the self-defense, then he heard at least some of the factual evidence that's going to be presented. He definitely mentioned that he heard about the self-defense, and there's 2 minutes long of it, and he only stopped when the victim advocate interrupted him. So, and again, my biggest concern there is he hears it, and I'm not sure he's credible in that he stopped listening to it. I just don't know that that's something that we can make a determination of right now. Because ultimately we don't even have, maybe we need Amber and the officer as well to see if they heard any of this or saw any of it. Because right now we're going on his statement that they didn't hear it, they didn't see it. It's still super concerning because we give these orders specifically for that reason, and it's a violation of the order. And if there's no recourse for it, then why listen at all moving forward? So that's my major concern here. Is it's not just him. It's, in this particular instance, there's a reason why these orders are given. And this is really, Your Honor, this is not ideal for the defense either. I want to make this clear. But ultimately now, I think moving forward, we don't know what he knows, and we know he knows at least 2 minutes of what was going to be presented, and now he has plenty of time out there to think about a response to that. So because of that, Your Honor, I think it's appropriate to unfortunately have to rule this a mistrial.
All right, Mr. Savage, your response to the motion for mistrial?
Though the facts are, though the fact of the matter is obviously concerning, I do not believe it rises to the level of a mistrial. I believe that the witness ultimately is credible. I believe that, basically, as I heard, his statement was that he just heard prove 4 ways if he's guilty or whatever, and I believe that based on that and his statement that he did not hear any of the alleged facts, that we can proceed forward that he heard only portions of when I was dealing with the self-defense instruction materials, which, and based on my recollection, I do believe made up about half the time frame of my opening statements. If we do, or if the court does see fit, or feels that perhaps additional testimony is necessary, specifically on the matter of whether he stopped listening to it, we do have another witness in the form of the victim advocate that instructed him to stop, and I'm sure she would be happy to testify under oath as to the specific events occurring afterwards. And furthermore, I would just note that he also testified that he was the only one listening to this and not the other witnesses.
All right. Well, I think Mr. Tainted brings up a good point in that we don't know whether or not he shared anything that he heard with any of the other potential witnesses. As far as the law enforcement officer is concerned, I'm not very worried about that because he's already familiar with the allegations are and the claim for self-defense. What concerns me more is the lay witness. I've received word from court personnel that she was actually watching it as well, so I'd like to bring Ms. Jones in at this time.
And that Your Honor, that also then calls in. That also calls into question everything he just said, because he just said no one else heard or watched that video.
We haven't heard from Ms. Jones yet, so let's not put the cart before the horse, or the hearse, as it were. Jones, please come forward.
Raise your right hand. Do you solemnly swear or do you affirm the testimony about to give is the truth, the whole truth, nothing but the truth, and nothing but the truth? Yes. Please have a seat. For the record, we're going to give your name to spell your last name
Amber Jones, Jones.
and your address.
So, Ms. Jones, you're here because it was brought to the court's attention that Mr. Harvey, against the court's order, was watching the live proceedings on our YouTube channel. Are you aware of that fact?
I wasn't until she had walked in there.
Now, I'm going to ask you a question. I want you to think carefully before you answer it.
Yes, sir.
Because you are under oath and subject to the possible prosecution for perjury, and I want you also to be aware that there is a camera in the witness room that is monitored by the IT department.
Yes, sir.
Did you watch any of the proceedings, or were you able to hear from Mr. Harvey's phone, or did you use your own phone to watch any of the proceedings in violation of the court's order?
I had sent the link to my girlfriend, but I did overhear it from the other phone as well.
And did you hear everything that was played up until the time when Mr. Harvey turned it off?
A lot of it, yes, sir.
All right. And what specifically did you hear?
Part of the opening statements, I believe.
Which opening statements?
I don't know who was speaking.
You didn't see, you didn't have a visual, you didn't look, you weren't looking at the phone?
No, sir.
Mr. Tam?
Did you hear two different voices giving opening statements?
I think so. I
So
couldn't
then
really
you-
differentiate. It wasn't super loud.
Did it sound like two different voices?
Yeah,
Okay.
yeah, sorry.
So then that would have been, you heard one opening statement and then you heard another opening statement.
Yeah.
Your Honor, that's certainly not what we just heard.
Do you have any other questions?
No other questions, Your Honor.
Mr. Savage?
Where were you sitting in the room in relation to Mr. Harvey?
Two chairs over from him.
2 chairs over
To
from
his
him?
right, yeah.
Okay, so there's a chair between the two of you?
Yeah.
Was anyone sitting in that chair, or was it
No.
empty? It was
It was
empty?
empty.
Okay. It was approximately how loud was the phone playing? If you could quantify that.
I mean, loud enough to hear voices, but I couldn't hear details or anything.
So
If
could
that
you,
makes sense.
so could you actually make out intelligible words, or just
No.
sound?
No.
You could not hear intelligible words?
No, I just heard voices, but I couldn't make out what was being said.
Okay. So you didn't hear any of the actual,
No.
what was being talked about?
No, sir.
Okay. How was Mr. Harvey holding his phone?
Just up to his ear,
Okay.
like the side of his head.
Okay. Was he holding it up to the ear on the side that you were on, or the opposite side?
I wasn't really looking at him.
Okay.
I don't recall. I was watching videos on my phone.
What were the videos that you were watching on your phone in any way related to this case?
No, I was just on TikTok.
Got it. Okay. Do you have any reason to think that Mr. Harvey knew that you were listening to what he was playing on his phone?
I think so.
You don't think so? Okay. Nothing further.
Did Mr. Harvey inform you of what he had heard specifically?
No, sir.
And I remind you, you remain under oath. He didn't tell you what he had heard about what the argument, what the attorneys were saying?
No, sir.
Anything else, Mr. Itam?
No questions for her, though.
Anything else, Mr. Savage?
There you are.
Ms. Jones, you may step down and return to the witness room. This court doesn't raise its voice very much, but it's very much tempted to bring Mr. Harvey back in here and raise its voice considerably. I think the court has to err on the side of caution here. If a witness was tainted by listening to a party's claims as to what happened, the danger of them tailoring their testimony to conform with those claims is more than just speculative. The court does not find Mr. Harvey to be terribly credible, at least as it relates to his use of his phone and what he saw and heard. I'm not entirely sold on Mrs. Jones's testimony either. As I said, I'm inclined to err on the side of caution here. Mr. Thomas has a right to a fair and impartial trial. While I wouldn't call it witness tampering per se, anything that calls into the integrity of the trial process as it relates to proof to be offered in support of a claim of legal culpability could very well jeopardize the defendant's due process rights to a fair trial. While I certainly don't want to have to try this case again, I see no other option but to grant the defendant's motion for mistrial. However, I find that it was not done willfully by the state, and therefore double jeopardy does not prevent the state from prosecuting Mr. Thomas at a trial to be set at a later time. That being said, I will prepare a written entry to that effect, and probably will do a little bit of research about what sanctions, if any, the court can impose upon Mr. Harvey in the form of financial penalties for the cost of wasting everybody's time here today. So, that being said, if either of the parties wish to be heard in that matter, you're more than welcome to submit briefs. If not, you don't need to worry about anything. My office will be in touch with your office, Mr. Itam, to get a new court date, and I hope that it will be very, very soon. Do you have anything else that you need to bring up on behalf of the defendant?
No, Your Honor, I don't think
Anything
so.
else on behalf of the state of Ohio, Mr. Savage?
No, Your Honor.
All right. Counsel is excused, as are the witnesses. Let's bring the jury back in, and not on the record. I'm going to go ahead and address them informally and let them know what's going on. Actually, you know what? No. You can take us off the record, but I'm going to put on the record declaring the mistrial. I will. Please be seated. The record should reflect that the jury is now back in the courtroom. We're on the record in 25 CRB 00287, State v. Thomas. Defendants present with counsel, the prosecutors here as well. Well, ladies and gentlemen, as I mentioned, there was an issue that was brought to the court's attention that called into question the possible integrity of our proceedings here today. Based upon my discussions with the attorneys, the court finds that it's not possible to go forward today. And so your service as jurors is going to be terminated here momentarily. You certainly have my thanks, and I will come into the jury room just to speak with you briefly after we've gone off the record. But I want to apologize because we were fully prepared to go forward and have this tried to a verdict today, and you certainly have my apologies that we're not going to be able to do that. So at this time, we'll go ahead and take our recess, and counsel and their parties and witnesses are excused.
All rise.